All right, ladies, are y'all ready?
We're ready.
Okay, my name's Carolyn Olson, and I am the first assistant county attorney in Colorado County. So I want to kind of explain to you what our office does. We are a county attorney with felony jurisdiction, which means we prosecute all of the criminal cases in Colorado County, from Class C tickets in the JP court all the way up to the felony, which this young lady in the middle is going to be involved in. The felonies are the ones where somebody can go to prison, okay? I have been working for the county attorney's office since 1997, and when I started, I was handed over the CPS work. And so I've been doing it for a long time, and over those almost 20 years, things have changed as we've gone along, and one of the best changes is the CASA volunteers, okay? As you all know, I'm assuming you know, that's why I was asking what y'all get trained on. The CPS caseworker has numerous cases, sometimes 30, and they are spread very thin. I assumed, and I thought I was right, that a CASA volunteer only has one case.
Hopefully. The majority
Hopefully.
only have one.
The majority, okay. And therefore, you all can concentrate on that one case. And I'm going to talk about a lot today about my most recent case, which we actually had a jury trial. And I haven't had a jury trial in a CPS case in, I think, since 2009. So it was a long time. But usually the cases will be worked out. Either the child will go with another relative, or the parents will relinquish their rights. The other option is a bench trial, which is where the evidence is presented to the judge. Rarely do we get a jury trial, but in this situation we did, and it lasted 3 days. And so I'm going to refer to that a lot because it's very fresh in my mind. And what Joe asked me to talk about today, I'm going to use examples because it's very important. I find that the CASA volunteer is a gold mine for me, okay? So you all have much more information about the children and the parents than the CPS worker is going to have, okay? Because you can concentrate on that case most of the time, and that case alone. I love the CASA volunteers. I love them. I mean, it's the best thing that ever happened, really. When I first started, I didn't have them, and when they came on board, it just has made a huge difference in my life. The other thing I want to explain to y'all is I'm the attorney, and I'm not on the ground, okay? I don't ever see these kids. I don't ever see the parents. I get all of my information from the reports, from your report that you file, from the report that the caseworker files, and what I hear in the courtroom, okay? I never see the child, I never see the parents. The parents are usually represented by an attorney, and I'm not allowed to talk to them. I have to talk to their lawyer. So you have no restrictions because you're not an attorney, because you're not a party. You get to talk to everyone. And I have had situations in the past where the CASA volunteer did not do that. So I encourage you to try to interact with everyone in the case, okay? Not just the children, but the parents, anybody that's involved. If the child is placed out of the home, and I want you to get to know those people as well, whoever that may be, whether it's a family member or a friend that has them, or the foster parent, okay? And especially if the foster parent is a foster to adopt type of home, not just a foster just to take care of the children. Anyway, I can't say how much thank you for volunteering. Y'all just do an incredible job. That's all I have to say. I just don't know what I would do without y'all. Okay, so if you'll look at your handout here, the parties in a case are the petitioner, which is the department, and I represent the department. So, as county attorney, we also handle all the civil work in the county. So a CPS case is not a criminal case, it's a civil case. And I get to do that, so I'm the one that represents CPS. We have 3 attorneys in our office. Jay Johannes is the elected official, he handles the felonies. I handle the misdemeanors and the CPS cases, and then we have a 3rd attorney in the office who his main job is juvenile and justice of the peace cases. So you'll see me most of the time unless something happens. Every once in a while, I not very often, but I won't be in court. Respondents are the parent or other person with a court-ordered relationship. We have a case right now where the child was given to a woman and she has power of attorney, and we had to make her a party to the suit because of that. So there may be a mom, a dad, or there may be 3 dads if there's 3 kids. Then there may be some other parties that are involved as well if they have a legal standing to be in the case. Then there's an attorney ad litem for the child or / children. If there's 5 children, there's 1 attorney ad litem. Not each child gets their own, just 1 attorney ad litem. And then the guardian ad litem, which is what you are appointed to be. The hearings in the case, there are several. The first one would be the adversary hearing, then comes the status hearing, then permanency hearings. There's an initial one, and then subsequent permanency hearings, and then the final merits hearing, whether it be a jury trial or a bench trial. And I'm sure you already know this, but the legislature, and I don't remember what year, changed the law so that we have 1 year. Once a child is removed and a court case is filed, we have to get permanency for these children within 1 year. Okay, so that's all the time that we have to work with these kids. There is a 6-month extension, which we do in, it's supposed to be rare, extenuating circumstances where we can get a 6-month extension. We've done it. And then there's a procedure where the child could be sent home, a monitored return, which would extend the case as well. That's when the parent has been doing everything, but they're not ready to terminate the case, but they want to send the child home and see how they've done. I don't think we've ever done that since you've been
Not in Colorado
Not
County.
in Colorado County. You have it done in other
Yes.
counties. Okay. So there are ways to extend the case, but legally, we're supposed to get permanency for these children within 1 year.
What happens if you don't?
It gets dismissed. So if the parents aren't doing what they're supposed to do, then we try to work out a solution, okay? So we have to dismiss the case, or we have to go to trial, okay? So if we don't work something out, like we go to mediation, and sometimes mediation, an arrangement is worked out that terminates the case. If we don't mediate a solution, then it's usually set for trial, a bench trial or a jury trial, and we have to do that before the 1 year mark, okay? And in the case that I referred to that we just tried, the jury trial, we did get a 6-month extension on that case. So what happened in that case is we mediated, and we needed an extension to try to work out the agreement that was made. It didn't happen, and so it got set for trial. Okay, the mediation didn't work. Anyway, the first hearing that you'll come to, and you guys are appointed as soon as the case is filed by me. So if CPS comes to me and they say we need to remove a child, I file the paperwork, and immediately on that day when the judge signs the order of removal of the child from the parent, he now, I'm sorry, we have a male judge now. We had two females and now we have a male. Will sign an order appointing the CASA volunteer. And it's great. You guys always go out and do your job, and you come to the adversary hearing already with information that I can use at that hearing, okay? You go out, you may see the home, the condition of the children, and I can use whatever you know at that hearing to make the removal of the child. So the judge signs a temporary order, okay, and then we have to have a hearing because in the United States of America we have this thing called due process, and we don't do anything long term without a hearing where the parents get to come and say they're due as well, okay? So that's the adversary hearing, and you can be called as a witness there. At the adversary hearing, the court shall return the child unless there is sufficient evidence to satisfy a person of ordinary prudence and caution that, and you can read these elements, it's in the third slide. I have gone to a hearing and had a child returned. I didn't have enough evidence. It happens, okay? The next hearing is the status hearing, and at that time the department should have filed the service plan, and there's only two purposes for the status hearing. To make sure that all the parties have been served and for the court to review and make the service plan an order of the court. And of course the service plan, which you probably already know, are the tasks that the parents are to complete in order to make their home safe. Now, one of the grounds of termination is that they didn't do what they were supposed to do on the service plan. But if a parent does everything they're supposed to do on the service plan, doesn't mean that we can't go forward if there are other reasons why those children should not be returned. So the service plan is not the do-all, say-all. They could follow everything and still be terminated, okay? So that's the purpose of the status hearing. It's not later than 45 days after the removal hearing when the department is named temporary managing conservator. Then, not later than the 180th day after the department is named temporary managing conservator, we have an initial permanency hearing. And that's when you're going to be filing your report, and the worker will file her report, and then everybody comes to court, and we have a hearing. And there are specific things, and I should have brought those hearing scripts that I have. There are specific things that I have to ask and find out for each hearing. It's all statutory. So every hearing, you're going to hear me ask the same questions over and over and over again because I have to. I have to ask these questions, and the judge will say some of the same things over and over again because he has to put those findings on the record in order to keep the child in the placement. My notes say that the court shall return the child at this hearing if they are willing and able to provide the child with a safe environment and the return is in the best interest of the child, or the court shall place the child with a person other than the parent if they are not willing. I've never had that happen. I've never had a child returned at a placement, at a permanency hearing. So I don't know. Usually they haven't started their services, they haven't completed their services. Anyway, it's just never happened to me. I've never had a child returned at the permanency hearing. Like I said, at an adversary hearing, sometimes I don't have enough evidence. I think I do, and the judge disagrees with me. It's happened. But anyway, the court hearings are very important for the judge because that's where he gets to hear what's going on in the case. And I'll talk about the difference here between the court hearings and the final merits hearing.
Did you have a question, Elizabeth?
Yes, I was wondering on the service plan, do the parents have any input, or like can they request certain services, or can they request counseling if they want it? Do they have any input into the service plan?
They, I don't know the answer to that question. I'm sure they do. CPS has specific things that they want in the service plan. They are to go over it with the parent. I will tell you that most parents don't think that they've done anything wrong, and so they don't think they need any services. So to answer your question truthfully or as honestly as I can is, yes, they probably have some input, but they probably don't volunteer to do any services. I would say most of them are like, that. I didn't do anything wrong. I don't know why you took my kid. Now, sometimes in a drug case, the parent will acknowledge that they need treatment, and sometimes even though CPS may say, well, you need to have a drug and alcohol assessment, and then if that shows you have a problem, maybe you'll go into treatment. I have had parents that go, I have a problem, and I want to go into treatment. So that does happen. I had a success story a couple of years ago. This woman had a child removed from her and terminated. And then we got another case on her, and I was like, oh my gosh, here we go again. Because you'll see these people over and over again. I mean, I have one lady that I can't, and every county has one, where she keeps having kids, and we keep taking them away because they can't do it. They just can't do it. And anyway, so this woman had a child terminated from her rights terminated, and then we got a new case, and she came in and she says, I want to go to treatment, and I'm doing this. Well, it's not going to, it worked. And we dismissed the case, and she took her baby and she left, and I was like, great. I mean, that's what we want to see. That's what we want, is for them to be successful.
It's also important to remember, too, that as a CASA volunteer, you can advocate for a service that may not be on the service plan. Say if there's anger issues, domestic violence within the household, and CPS has failed to put that the father needs anger management classes, or what they call BIP program, which stands for Batters Intervention
Prevention program. Yes.
Those are certain things that you can recommend. If you have a child with a specific medical diagnosis, for example, we had a child with severe diabetes, type 1 diabetes, and in the service plan, we requested that the judge order the mom take specific training at the hospital and have the doctor sign off that he thought the mom was capable of caring for the child.
Yes.
So we added that to the service plan. So knowing your child, knowing the parents, knowing the specifics to your case, where it's not always cookie cutter, is really important, and you do have a say.
Absolutely. I guess the most important thing to remember is speak up. In Colorado County, and I don't know how it is in the other counties, but when we come to a hearing, let's say I'm the judge sitting at the bench. Well, everybody stands in front of the bench, and that's how we have the hearing. And usually CASA goes last, and the judge says, Miss So-and-so, tell me what's going on, or what do you think about this, or whatever. And he means it. And Joe means it as well. Sometimes I say, I think such and such needs to be on the service plan if it's not there, just because I've seen something that I think should be there. Okay? So Joe's right. You need to get to know the parents and the children and the caregiver. Know your case and make recommendations. They may not always be followed, but if you feel strongly about it, absolutely speak up. Yes. Y'all have a great job. You really do. Where was I? Okay. So the permanency hearings, I was talking about the service plan. Was that the status hearing? Yeah. And then the permanency hearings are, how are the parents doing? We have this service plan. Do other things need to be added? That's one of the questions. Does something else need to happen? Speak up. That's your job. You're supposed to be the voice for the court, and your recommendations are regarded highly. Okay? And so if during the case you see something that comes up, maybe you didn't at the status hearing when the service plan was initially formulated, but you now see something else, yes, speak up and say you think that they need to do another service, something else. Okay? All right. And then the subsequent permanency hearings are held within 120 days of the previous hearing. Then when we get to the end, if the child hasn't been returned and there's not any agreement worked out, then it'll be set for a termination hearing. And in a termination hearing, there are two things I have to prove. I have to prove one of the grounds of termination, which there are 20 of them, and I have to prove that termination of the parental rights of the parents is in the best interest of the child. And I think that is the hardest part. It's so easy for me as the lawyer to prove a ground of termination, okay? That the parent didn't complete their service plan, or that the parent is in prison and they're going to be there for 15 years. So they're incapable of, providing a home for this child. Or they intentionally or knowingly engaged in behaviors that damage the mental or physical condition of the children. Those are fairly easy for me to prove. What's harder is the best interest, okay? And it's both. I have to prove both. If I don't prove if I don't prove the termination ground, but I prove best interest, I don't get termination. If I prove best interest, but I can't prove a termination ground, I don't get termination. I have to prove both. And normally in a case, I'm going to use the CASA volunteer to prove best interest. I will use the CPS caseworker, but as I said before, you guys usually are y'all have more information. And I brought my questions for the case that we just tried, the jury trial, and you'll see how extensive my questions were. When you go to visit the children, I would suggest if you can go to a visit with the parent, you absolutely need to do that. Because one of the things that you want to be able to testify to, if it comes down to a termination, would be how does that parent interact with those children? Were they appropriate? Is there a bond? Okay? So in certain cases, you won't always be able to go, but if you could go to a couple of visitations, that would be great, so that you can see the interaction between the mom and the children, and then if the dad visits, also, see how the dad interacts, and that's very important.
Do they have visitation if the parents are incarcerated?
No, that's not good for children, right? Yeah.
And we will, from time to time, have parents or attorneys for the parents request that, and the judge has always said no.
No, yeah, he always says no. That's not appropriate for them.
No, I didn't.
Yeah. So like I have a case right now where the father's in prison and he's going to be in there for a while. He doesn't have visitation. If he were to get out, he would get his visitation, but it's just, a prison is not the place to be visiting, not even the county jail. They won't let
So
him
if
go
they're
to
in
the jail.
prison, it's pretty easy to prove that that's...
Not always, because that ground, if they're incarcerated for more than 2 years from the date the case was filed, I additionally have to prove that there's nobody else that he can arrange to take care of the kids. So in this case that I'm talking about that we have right now, which I think I can prove that ground, he has named several people and they have been found by CPS not to be appropriate. So because of that, I probably could prove that ground of termination, because yes, he's in prison, he can't personally take care of them, but if he has people outside that are willing and able to do it, then that ground I can't meet. Okay? All right, so we'll talk about best interest here in a minute. So in a jury trial or a bench trial, well, no, I take that back. In a jury trial, the order of a trial is, the first thing we do is voir dire, and that is the process by which the jury is selected. And then each side gets to have an opening statement where they tell the jury what they expect the testimony to show. Then I go first because I have the burden of proof. So in a CPS trial, and I'm going to sound like my voir dire in a criminal court, there's several different levels of proof that a lawyer has to prove in order to do something. The lowest would be reasonable suspicion and then probable cause. In a CPS case, my burden of proof in order to prove my ground of termination is clear and convincing. So I have to present clear and convincing evidence that my ground of termination and best interest. In a criminal case, it's a little bit higher, and that's called proof beyond a reasonable doubt. So I get to go first because I have the burden. I have to prove my case, and everybody else goes second, and they poke holes in my case. So I represent the department, that's the petitioner, and then every attorney in the suit gets to cross-examine my witnesses. Then each respondent, which the respondent would be the parent or somebody else with a legal standing in the case, they get to put on their case in chief. And then I get to put rebuttal evidence on, which means I would try to rebut their case if I had some rebuttal evidence. And then once all of the evidence is in, we do closing argument, which is just our summation of the evidence, and we argue why you should terminate, and they'll argue why you shouldn't. And then the jury would go and deliberate with a jury charge. And the jury charge is a document that sets forth the law, and it asks questions. And then the jury goes and they read the jury charge, and based on what they heard during the trial, they answer these questions and come up with a verdict. In a CPS case, it's a civil case. It takes 10 out of the 12 to get a termination.
Could you discuss when they invoke the rule in a trial?
I will.
Okay.
Okay. All right. So your role as guardian ad litem, your role is statutory. As I said earlier, you're not a party to the suit, and you have specific authority to investigate, participate, and testify in the trial. Your records are confidential. You are not restricted from communicating with anyone involved in the case. And I wrote an example. So let's say the mom has an attorney and you want to talk to the mom. The attorney for the mother cannot tell you you may not speak to the mom. Okay? He can tell the mom, I suggest that you not talk to the CASA. Okay? But he can't control you. All right? So you can talk to the mom, the dad, the CPS worker, the ad litem, anybody involved in the case you guys can talk to if they're willing to talk to you. Okay? And again, if you will, get to know each of the parents if you can. Sometimes they're not around. Obviously, you won't be able to get to know them if they're not around. But if they're not around, then I'm going to ask you about that on the stand, Did you ever meet Mr. So-and-so? The father of child number 2. No, I didn't. Well, did you ever attend a visitation with Mr. So-and-so, father of child number 2? No. As far as I'm aware, he never visited at all. Are you aware of whether father number 2 ever sent any money to the caregiver, where the child is placed? Are you aware of whether he ever sent any money to help support his child while he was in care? No, he never did. Are you aware of any gifts, clothing, letters? Did he ever call? Did he ever write? He may be in prison, but maybe he sent letters all the time. Or he lives in another state and he sent money, he sent clothes, he called, that kind of stuff, okay? So even if he's not there, I'll ask you questions about that person, okay? You are entitled to notice of all court hearings, and you are entitled to participate in all court hearings. Your right to testify is in the family code, and the question about invoking the rule, when any kind of trial starts, the attorneys will say, I'd like to invoke the rule. And it's a rule of evidence that says if you're not testifying, you go out of the courtroom. The rule does not apply to the guardian ad litem. Okay, because you have specific statutory authority to testify. So at the last trial that we had, I told the volunteer, come and you're going to be here all week and you're going to sit at council table, which in a CPS case can be a lot of people. So in this case we had a mom and a dad and an ad litem for the children, and the department sends the caseworker for the department sits with me, and then the ad litem is there as well, and you're going to be there for the whole trial. Okay, so if your case gets set for a jury trial, just know you're going to be there every day, all day. The only thing you don't get to do is you don't get to ask questions because you're not a lawyer. Okay, but you get to stay in the room. Now the purpose of the rule is so that people don't tailor their testimony to what somebody else testified. Okay, so Mom and dad get to stay in the room, and you get to stay in the room. So obviously they get to hear what everybody testifies to. But the purpose of the rule is to prevent that, okay? You know, so if a witness gets up on the stand and testifies whatever, then if you were another witness, not you as a guardian ad litem, but just another witness, you might tailor your testimony to that, okay? But this is what you want me to talk about. It also means that if you're in the courtroom, invoking the rule means you cannot talk about the case to anybody, okay? So once the rule is invoked, you can't talk to anybody about the case, what you've heard, or anything except me or the other attorneys, okay? If you talk to somebody about the case and somebody overhears you doing that, the case it'll be a mistrial. And I personally have had that happen before in a criminal case. So I'll tell you what happened. We were trying a case, it was a drug case, and there were 3 or 4 officers that were at the scene. And one of the officers got up on the stand and the other officers were out in the hallway. And the defense lawyer's son, who's a lawyer, was there, but he was out in the hallway. And the officer that was testifying got off the stand, and he walks out the door and kind of was mad about what happened and said something. And the defense lawyer's son, who's also a lawyer, told the judge. And we had to have a hearing on it. Well, what he was doing was just shooting off his mouth, you know, just shooting off some steam. So he didn't really violate the rule, but we had to have a hearing on it, you know, and they wanted a mistrial. So don't talk about the case. Once the bench trial or the jury trial, if somebody invokes the rule, you don't talk about the case except to me, okay? Don't talk about it to the CPS caseworker. Don't talk to Joe about it. Don't talk to anybody but me, okay? So the rule applies to you, but you don't have to leave the courtroom,
So
okay?
the question,
Yes.
we can't talk to Joe as our supervisor?
No,
Not once the trial starts.
not once the trial starts.
Specifically regarding
I
the trial?
yes, regarding the trial. Yes, you can talk to her. Just don't talk to her about what's going on in the case, okay?
But we could
Obviously.
ask her questions.
About what?
You will have already been prepared for your,
Okay,
Your-
okay.
For the trial,
What kind of
unfortunately.
questions? What kind of questions are you talking about?
Well, I guess like the trial's going on and something comes up and we have a question
No,
about the best interest of the child.
you talk to me,
Okay,
okay?
and we can take notes.
During the trial? Sure,
Okay.
you can take notes. Yeah, but you're gonna be prepared. I spent hours with the last case, okay? The CASA volunteer came in. I spent a couple of hours with her initially, and then we, you know, so that's how I handle my cases. I like to talk. I will not put a witness on the stand unless I've talked to them, okay? It's too scary.
And I guess some of our questions sound kind of silly, but we haven't been through the process.
They're not silly.
so.
They're not silly, not at all. No,
Okay.
you're not a lawyer. You've never been to court, I'm assuming. No, nothing you ask is, like I said, I've been doing this a long time. And when I started, I didn't know anything. So I had to learn it all. So you will learn it as you go. Hopefully you'll just take some of the tips that I'm giving you that will help me. That's the perspective I kind of wrote this talk, was how you could help me if it comes down to a trial, or how you can help me move the case along, you know, how you can help the case, your children. So that's the other thing. The guardian ad litem that's appointed to the children is a lawyer. Attorney ad litem, The attorney that's appointed to the children is called an attorney ad litem. You're appointed as the guardian ad litem, and y'all have 2 different jobs, okay? The attorney ad litem has to advocate for what his clients want. And I know they're children, but that's his job. If they're old enough and mature enough to express their desires in the case, then he has to advocate, he or she has to advocate for the child that way. Your job, on the other hand, is what's in the best interest of the children, okay? Now, I don't think I've ever been opposed, the department has not been opposed to what CASA wants. So usually the department and CASA are aligned. They want the same thing for the child, okay? Whether it's to reunite or whether it's to terminate, y'all are usually aligned as far as that goes. You have cases where you're not?
Yes.
Okay. Okay. Have you had that in Colorado County? Can you think of a case?
Yes.
Which one?
We had one where the foster parents filed an intervention and CPS was having to recommend placing the child with the relative. And we felt it was in the child's best interest to be.
Which one was that? Okay. So Miss Dancy and, yeah, okay. All right. So sometimes you all are at odds. But most of the time you have the same idea. Okay, not always, but sometimes. This past case that we just tried, the ad litem was opposed to what CPS wanted, which was unusual. But that's how it played out. So we weren't aligned on this. CASA wanted what the department wanted, but the ad litem for the children had to advocate for going home because that's what they wanted. All right. There was a child or two that was old enough to express that. All right. Now, when there's a baby involved, the attorney ad litem ends up, obviously the child is a baby, can't tell the attorney what the baby wants, so he kind of has to depend more on what's in the best interest of the child. Okay, but your job is always what's in their best interest, okay?
I was wondering, you said invoke the rule?
Yes,
What rule is that?
that's the one we just talked about, where you can't talk about the case
So invoking a rule of confidentiality or just not talking?
during the trial. Invoking the rule only comes during a trial, okay? And that's where all the witnesses will be sworn in, and then all of the witnesses leave. Okay, they cannot be in the courtroom to hear the other testimony, and they're not allowed to talk about the case. So, and that's where I was talking about, as the guardian ad litem, you're not excluded. You get to stay in the courtroom, and you get to hear everything that everybody says, but you can't talk about the case. Okay, when there are recesses during the case, and once you recess, you can't go out in the hallway and go, wow, guess what mom said? Oh, Joe, guess what the dad said? You can't do that, okay? You can come to me and say, Miss Olson, I have a question, and whatever it is, I'll see if I can answer it, okay? All right. All right, so you have the right to testify. The court can compel you to testify or give you an opportunity to testify. And you will testify about the best interest of the child and your basis for that recommendation. Again, going back to all the hearings before the final merits, you get to testify each hearing. The difference between the statutorily mandated hearings and the final hearing, the preliminary hearings are very informal. We'll stand in front of the bench where everybody's sworn in that's going to testify. The lawyers can and do object sometime, but it's very informal, okay? Well, there's some formality to it. The judge has everybody announce their name, we all get sworn in, we take turns. It's not just a chatty conversation. There is some structure to it, but it's just less formal than a bench trial. Also, the hearings in front of the bench are recorded by the judge on his computer, and at a final merits hearing, there has to be a court reporter, and I'm jumping ahead of my notes maybe. And we're going to go over some of those rules as well. Any attorney can call you to testify. The court can call you to testify. And if nobody calls you to testify, you should speak up. Okay? So in the informal hearings, the adversary hearing, the status hearing, the permanency hearings, If nobody asked you to testify, then you should say, Your Honor, I would like to testify, okay? And at that point, you just narratively tell the judge what you want to tell him, okay? What you think's important for him to know, all right? I will tell you that Judge Stuckey, who's the judge in Colorado County, always wants to know what CASA has to say, always. And he usually puts it, Miss So-and-so, tell me what's going on in this case, or what do you have concerns about, or whatever, and he wants to hear it, okay? Even if you say something negative about CPS, do it. I mean, it happens all the time. I think y'all disagree. CPS will say something about what medication they're taking, and the CASA volunteers say, nope, that's not right.
Yeah. That's old information.
Yeah, but the judge needs to know those things. Yeah, sometimes their information is old. I think something has changed. Okay. But, and I've never, in the informal hearings, I've never had to call the CASA worker. Maybe once or twice. In a jury trial or a bench trial, I'm always going to call you, okay? I can't imagine why somebody wouldn't, why the attorney for the department wouldn't call you. I guess I wouldn't call you if you totally opposed to what we want. Then I might not call you. I guess in that situation, I wouldn't call you. But if nobody calls you, and I guess if you're opposed to the department's position, then one of the other attorneys for the parents will call you. Has that ever happened? That nobody called and the CASA worker had to go, hey.
In the past, in some informal hearings, we had that issue, but
Okay.
it's improved. We've had some conversations with all of our judges,
Okay.
and just over the years, they've seen the impact that your
That your
testimony has, and so now they automatically
Okay,
ask
that's
for your
good.
input.
Judge Stuckey always wants to, and I have never had a judge that didn't call the CASA volunteer to tell what they thought about things, or what was going on, or what needed to be changed or added or whatever. Okay. All right, so what is the best interest of a child? And this is very difficult. There are 9 court-developed factors that I've listed here on these first 2 slides on page 5. And there's cases that tell you what that means. So I'm gonna go over these questions that I asked the CASA worker to help get out what the best interest is. But obviously the desires of the child, the emotional and physical needs of the child now and in the future, the emotional and physical danger to the child now and in the future, the parental abilities of the individual seeking custody. Now this is why it's important that you get to know the parent. Go to a visitation, because you will not be able to testify about parental abilities of the parents if you don't see them react with these children, and or know that they've gone to the visitation, or know that they're, providing something for that child, okay? But that's very important in best interest. The programs available to assist these individuals to promote the best interest of the child. What that means is, did they take advantage of the services that were offered them? Okay, they're saying, don't take my child, but yet I didn't go to parenting classes, I didn't go get my drug and alcohol assessment, or if I did and they said I needed inpatient treatment, I didn't go. They're not taking available of those programs. The plans for the child by the individuals or the agency seeking custody. What that one is talking about is what plans do the parents have, or if the department is seeking termination, what plans does the department have for these children? If the department has a family willing and able and ready to take these kids and adopt them, and the parents haven't done anything, whose best interest do you think it is for the child? Well, the agency, because they've got somebody that's willing and able and ready, okay, to take these children. And usually those people have been vetted and they're foster parents, and we know they're good people, right? Versus have the parents taken advantage of all that? What are their plans, okay? The stability of the home or the proposed placement. A lot of times the service plan for a CPS case will say, get and maintain housing. These people sometimes don't have a place to live when these children are removed. We have people that are homeless and they drop their kid off to this person, that person, and the other person. A child needs a home. So usually on the service plan, they'll say get a home and be stable, okay? A lot of these people don't have jobs, may not be able to get a job, but they need to try. They can get some kind of job, you know. They're usually not always disabled. Some of them are. A lot of them can be disabled, whether it's mentally or physically. And then, of course, they can't. And then, of course, the acts or omissions of the parents, which may indicate the existing parent-child relationship is not a proper one. Well, obviously, acts or omissions would be the reason they were removed in the first place. But again, acts or omissions during the case, and you are the eyes and the ears. What did they do during the case? Did they come to visitation? Did they take every opportunity to get that child back? Okay? And then any excuse for the acts or omissions. Then there's a whole list in the family code of other factors that can be used in determining best interest. Now, when you get up on the stand, if I asked you, Miss So-and-so, do you think it's in the best interest of the child that the rights of the parents be terminated? And you say yes, and I move on, and I'm done with you, I haven't proved best interest, okay? I'm going to ask you the facts, and only the facts that support your opinion, okay? So what I'll get out of you at trial is what we just talked about, the facts that support these elements of best interest. And I may at the end ask you, is it, in your opinion, would it be in the child's best interest to terminate the parental rights? Yes, you can say that, but I got to have the facts that support your opinion, okay? So I will ask you about those things. And then at the bottom of page 5, I list some things that you could talk about. What observable changes have you seen in this child during the case? Okay, so think about what you saw when you went out the first time before the adversary hearing and compare it to what you see. A lot of times the children change dramatically in that 1 year period, okay? And you are there to see it. I'm not. Again, I never see these kids. If they're old enough, they may come to court every once in a while, but I got to get all this information. I don't get to testify. I don't get to see the kids. I have to draw it out of you and the caseworker. Anyway, will adoption be likely? Does the child have a preference? Does the child have special needs? Was there an incident so severe that the parent could never be trusted with the child's safety? What were the child's circumstances at the time of the removal? What is the mental and emotional condition of the child today versus the date of removal? Or their physical condition. A lot of times we'll have a child that has developmental needs, and obviously the parent hasn't done anything about it. CPS obviously does a lot about it when they get the child. You know, they get them medical care, dental care, ECI, early childhood intervention comes in. They may have a speech problem, a walking problem, you know, just a developmental problem. Of course, you have to, when the child is very young, sometimes the parent, those things haven't shown up yet. So it just depends on the case whether I can use all of that information. Know your duties. This is on page 6 on the bottom left-hand corner. Within a reasonable time period after your appointment, interview the child if 4 years of age or older, and each person that has significant knowledge of the history and condition of the child. Mom, dad, grandma, anybody that lives in the house, that would be great. And then these are family code duties. Seek to elicit the child's express objectives, consider them without being bound by them, encourage settlement or alternative dispute resolutions, and perform any specific task directed by the court. And I know the court does that too. Sometimes the judge will order you to do something in the case. What was it? Glasses for somebody or something, wasn't it? Mm-hmm. Alyssa, yeah. Mm-hmm. Anyway, if the case gets down to trial, hopefully you will have taken notes during the case. And what you should do is take notes right away. The sooner you put them down on paper, the better your recollection is going to be. Every time I come out of the courtroom, I go write down notes on everything that happened so that I don't forget. Because even in my CPS cases, every time we have a hearing, of course I take notes, but they're brief. And then I go back, after court's over, I go back to my office and I write down the details of what happened so that I remember, so that I can remember what mom testified to or dad testified to. And, you know, I can say, oh, Mom, do you remember at the hearing on March the 22nd that you testified, you know, whatever. So write down your notes. If you go to a visitation, you have observations, put them down on paper. That'll be very helpful. This is through the case, you should do that. And then when it comes down to having to testify, go over all your notes. You'll meet with the DFPS attorney, which is me in Colorado County. I always meet with my witnesses, so don't panic about that. I'm not going to stick you up on the stand and start asking you questions that I haven't already asked you, okay? I'm good about that. Dress appropriate, look your best. I debated on what I was going to wear today because I kind of wanted to give you an example. I'm not saying you have to wear a dress, but don't come in jeans. You know, don't come in shorts, crop tops. Crop pants. You know, this is a courtroom, and there's a decorum about a courtroom. It's called respect for the process. So dress appropriately. Be punctual. Review all your notes. Watch your body language. This not so much at the statutory hearings, but at a jury trial. That's very important. You don't want to be rolling your eyes during somebody's testimony. In a jury trial, the jurors look at everyone and they notice everything, and they can make a decision based on that, and they do. Okay.
Even something so simple as who you're sitting next to during the trial.
Okay, an example, what are you saying?
Well, just sometimes, especially maybe even at a regular hearing at the beginning of the case, maybe you don't want to be sitting next to the caseworker if you're still trying to build up a rapport with the parent, so to speak.
Good point.
So you can say hi and have conversations with them, but depending on who you sit next to, it might rub somebody else in the case a wrong way, which could hurt your future
contact with
them.
a parent. Okay.
So just be cognizant of that. It might be something totally innocent.
Sure.
But just be cognizant of that.
Sure. Okay. In a trial, you will rise, even at the hearings. When the judge comes in, you rise till he tells you to sit down. In a jury trial, you rise every time the jury comes in. It's just a sign of respect for the process. Most important when you're testifying is to tell the truth. Okay? Don't embellish. If the parents did something good, tell me about it. Okay? I mean, it is what it is. If I'm trying to get across something bad and you go, no, she actually did, you know, whatever. I want the truth. We're seeking the truth. We don't want you to make something up, okay? So if the parent did something good, you should testify about that, okay? Hopefully, if we're going for termination, the bad outweighs the good. But do tell the truth. Absolutely. Tips for testifying: listen to the question and then answer the question. If you don't understand the question, tell the person, I don't understand what you're asking me, okay? It's not a race to get off the stand and in haste to outguess the defense lawyer or the parent's lawyer or whatever. People get so nervous, you know? You're up there to tell the truth. It shouldn't be nerve-wracking. I know it is because I've been on the stand myself. So I know it is nerve-wracking. But if you're telling the truth, it shouldn't be. So just make sure you understand the question that's being asked and then answer the question. The other thing I was talking about at the informal hearings, the judge records it at a termination hearing, whether it's a bench or a jury trial, there's a court reporter. And she can only take down one person talking at a time. So wait till the question is finished before you start talking, okay? Because she can't take down two people at once. She's going, you know, Carolyn and what I asked, and then witness what she said. And sometimes it can get rapid fire. So just remember, you try not to testify over each other because the court reporter gets really mad. It's very hard for her to do that. Don't guess or speculate. If you know the answer to the question, answer the question. If you don't, you can say, I don't know. Okay? The bad thing when you're testifying is to keep saying, I don't know, I don't know, I don't know, or I don't remember, I don't know. Okay? So that's why I was talking about taking notes during the case, and then prepare for your testimony. And I will help you with that, because I always will talk to you beforehand about what I want you to what questions I'm going to ask you. Be pleasant, polite, and calm. Don't get argumentative. Address all parties by their last name, their surname, which I have a bad habit of calling them by their first name. And then if somebody objects during a trial, you don't need to understand what's going on. Just know that if somebody objects, you stop talking. That's really the most important thing. I'm not even going to go over sustained and overruled. Just know when the judge makes his ruling and you don't know what to do, he'll say, you can answer that question. Now, by the time they argue about it for 5 minutes or however long it takes, you may say, I've forgotten the question. Could you repeat the question? And son of a gun, sometimes I go, I have no idea. I don't know what I just asked. I don't know. So I'll go, well, let me rephrase that, or can I just move on? So if it was important enough to be objected to, it was probably something I need to ask. But sometimes I totally forget what I asked. And then, you know, and a part of the plan for an objection is just for that purpose. Attorneys will object just to get you, just to knock me out of my rhythm. Okay, so I'm like giving you these questions and he interrupts because he wants to throw me off, and sometimes it works. So anyway, the important, yes?
That was one of my questions, like, in that situation, but what if, like, they're asking a question that's a really long one, can you ask them to repeat or some part of it?
Well, it should be, if something like that happens where he asks a compound question or asks several questions in one question, yes, you can say, you know, that's confusing to me, that you're asking me several things at once, I'm not sure how to respond, because they might do that just to get a yes out of, you know what I'm saying? So yes, if the question is too confusing, just say so, absolutely, okay? If you don't understand the question, yes, absolutely say it. You know, that was an awfully long question, I'm not really sure what you're asking, okay? Okay, let's see. Don't take documents or notes to the stand. You should know your case, okay? And what I'm amazed is that so many people at the statutory hearings, they come to court and they can testify without their notes. I'm a note person. If I don't have my notes, I can't remember everything. I'm amazed at the ones that do. So when you come to one of the statutory hearings, if you need your notes, bring them. Do you all
The court report.
allow that?
Yes. Everything you need should be in your court report, which everyone at the hearing has already received anyway.
Right.
So.
Right. I don't know. It seems like when you guys testify, there's a lot more information, or something that's happened since the report was filed.
Yes.
You know, that they remember. Ursula has an uncanny recollection of specific details, and
Yes.
I'm just not like that. You know, I'm getting old. I can't remember everything. If I don't write it down, it didn't happen. You know.
Yes,
I can't
specifically, if there's a
remember.
medication change or a concern about the medication, Judge Stuckey's always very
Wants to know
concerned
that.
about that.
He
you
is,
know,
yes.
what is that medication for? What is the diagnosis? Are there any side effects? How long have they been on it? Why was there a change?
Yeah. But if you need your notes at those hearings, that's fine. The reason you don't take notes, the reason you don't take notes up to the stand is a evidentiary rule, So if you're testifying from notes, then the defense attorney, the respondent, the opposing attorney has a right to look at those notes, okay? And that's why we don't want you taking notes up, okay? I have that all the time, because I'll give the CASA volunteer my questions that I'm gonna ask them. Can I bring these with me? Nope. Read them over. They're just for you to get knowledge of what, familiar with what I'm gonna ask and what I'm after from you. You study them at home, but do not take those questions up on the stand. Yeah, you should know your case before you get up on the stand. Okay, let's see what else. We did invoking the rule. Okay, and then common objections, again, there's a list of them here. I don't know that you need to be too worried about it. Relevance just is, an attorney will say objection, relevance. If it has some relevance to the case, it's going to be allowed. Hearsay is the biggest one, and I think I gave an example in here somewhere. So if I get you up on the stand and I say, Miss So-and-so, what did the mother tell you at visitation? That's not hearsay, okay? What the mother told you is not hearsay because she is a party to the case, and it would be an admission. If I ask you, Miss So-and-so, what did the therapist tell you? That's hearsay, okay? So you cannot testify other than to what a party said, otherwise that's hearsay. But if a party tells you something, if mother tells you, I just couldn't resist. I used cocaine last night. Oh my gosh. That's coming in, okay? And they're going to object, but it's not hearsay because she's a party to the suit. She's just made an admission to you that she's still using drugs when she's not supposed to be, okay? And that's an extreme example. But the parents will, if you get to know them and you have a relationship with them of some sort, they may tell you things that we can use if termination is in the best interest of the child. And I'm not saying we're not always seeking termination. I don't want to come across like that's what we do. We just want these children to be in a safe place. And whatever place that is what we advocate for. So, any questions? Wow, that was a lot of information. Have I talked for an hour? Oh, I did. I went over, sorry.
That's okay, no.
All right, and I was gonna go over these with you as well. Now, these are the questions that I asked the CASA volunteer in this last jury trial. And you'll see how, what I'm looking for. Now it has some of the facts of my case. Don't share that with anybody, that's just for you. But you'll see what's your name, what's your role, what's your education, training, are you employed, where, how long, what do you do. These will change. If you're retired, then you had a job before. If you're a stay-at-home mom, great, you're a stay-at-home mom, okay? There's all kinds of benefits to whatever it is that you do or whatever you did, okay? Explain to the jury in a jury trial. I'll ask a lot of questions that I wouldn't ask in a bench trial. Because obviously if it's a bench trial and the judge is making the decision, I'm not going to ask you what is CASA and what is your role.
I'm having some trouble with
because
the connection.
the judge already knows that, okay? So in a jury trial, I will ask questions that I obviously wouldn't ask because the judge knows all those things, okay? Then I'll ask you when you became involved. Did you go to the home? Visitation with the parents, father's visitation, mother's visitation. And I'll ask you, that's why I want you to go to visitation. And then you'll see, when did her visitation begin? The mother, was she appropriate with the children? Did she seem bonded? Did she parent the children responsively and appropriately? How did the children react when the visit was over? Have any children voiced wanting to reunite with the mother? How about with the dad? Did the mother contribute to the care of the children? And then I'll ask you about where they're placed, and that's important, especially if the placement is wanting to keep the children, okay, in a termination suit, if they are wanting to keep the children. I'm going to ask you all about those people as well. What's their house like? What are they like? How many children do they have in the home? Is there appropriate room for all the children? And then you'll see down here, tell me the difference in the children today versus when you first got involved with this family. And I go over each of the children, okay? What they were like when the case started, and what are they like now? Has the mother visited since they were placed there? Have you been able to keep in contact with the mother? Do you know her living arrangements? And this goes back to they have to have a stable home. Does she have a job? Do you know whether or not she could support these 5 children on her own? And then tell me about other relatives that have asked to be considered as placement. That's important if there are other family members, why they are not appropriate, okay? And then are you aware of the plans the department has? Because that's important for best interest as well. Have you been to any of these placements' homes? And then I'll ask you about their home. Stuff like that. Actually, you know what? I'm going to take those questions back. It's because it's got too much information in it about
Just to be safe.
about my case. Yeah, just to be safe. But you'll see how extensive. 3 pages of questions, okay? And you'll notice that all of those are about best interest, okay? And so I rely a lot on the CASA worker to prove up the best interest ground. You can also prove up my termination grounds sometimes as well, okay? So, what else? I know I keep talking.
No.
I'm terrible.
I appreciate you so much coming in and talking to our new advocates about what to expect. If you ever have a question about a procedure or process in court, she's always open to talking and answering questions. So,
Yep.
I know most of them observed the Colorado County Court recently.
Okay.
So they've already kind of seen you in
Come to
action.
court. Okay.
Um,
Yeah, so you saw how we did that.